emerging issues for employers, H-1B, and L-1 site visits. Barbara, would you like to say hello to the group today?
Absolutely. Hi, everyone. Thanks for joining us on this timely and very important topic because we do see quite a few random and unexpected USCIS site visits from our clients, usually when they least expect it sometimes. So it's good to be well prepared. So thank you for joining us.
Thank you very much. So just a little bit of preliminary information. If you have a question on your control panel on your screen, you should be able to send a question on either a chat or a question actually to us. If you have any questions during the broadcast, please feel free to send them. I may or may not get to them at during the broadcast. I may do them at the end, but I will be monitoring them, and we may stop in the middle to answer them. So please do feel free to do that. Uh, about 30 minutes ago, I sent an email to all of the registrants with a copy of the PowerPoint that you're going to see now on the screen. I also have that on a handout, which I believe that you can download on the GoToWebinar control panel if you didn't receive that email. So let's start. The reason why we decided to do this particular webinar is because over the years we've really seen an increase in the number of site visits by the USCIS for both H-1B and more recently the L-1 visa category. And we're going to share with you some stories of some clients that did have site visits, number one. And number two, we're going to give you sort of an introduction as to what the company needs to prepare for when there is a site visit. Um, in 2009, the USCIS started site visits, and they started with the H-1B visits. Last year, they started with L-1 cases as well. Now, some of you who have applied for, or companies that have applied for individuals obtaining H1 and L1B visas may know that you pay a $500 fraud prevention and detection fee when one applies for a new H1B or L1 worker. That money is going towards in a majority of the money is going towards the funding of these types of site visits. So that's why the government is doing them, because they had a mandate to uh, do these site visits as part of the fraud prevention and detection fee that they're receiving. So basically, what happens when a site visit? First of all, let's talk about when a site visit happens, and we're going to talk about that a bit later. But the government says that the site visits are random. So how do you know if you're going to be chosen or if you're going to be targeted for a site visit? Well, it's very hard. I was speaking with Barbara yesterday, and she mentioned that a lot of large companies also had site visits, and they're not necessarily targeted. But so we think that they're random. The government says that they're random. At the same time, in my experience, I found that a lot of smaller companies, maybe companies that have one or two employees, or companies in certain industries, tend to get more site visits than others. That's just been my personal experience. For example, we've seen a lot of site visits in the hospitality industry, for example. So it's hard to say why someone gets a site visit, but everyone needs to be fully prepared for a site visit. Barbara, did you want to add anything at this point? Go
Yeah,
for it.
I think one of the things that David mentioned is right that it is random. So even though it may seem that some smaller companies may be targeted, there are actually site visits for larger, mid-size, basically any company that files an H-1B petition. In particular, one of the things to watch out for is if you actually have an end client issue where your foreign national is actually working not in one of your offices, but maybe at a client site, it's important to warn that client as well, because ultimately the site visit will occur where where the beneficiary for the H-1B or L-1 petition is actually located, even if it isn't a company office. So what David said is true. It's like sometimes it could be small companies. Basically, is following that particular foreign national to verify the integrity of the H-1B filing or the L-1 filing.
Yes, and I think that's important, Barbara, because the on the form when you file for your L1 or your H1B, you indicate where the worker is being placed. So the officer could show up at either the headquarters or at the place of employment. And I think it's important to have both sides ready to uh, welcome a visit and be able to deal with that visit. Now, the government says that it's trying to foster a culture of compliance within the system. I think to some extent that's true, but what we need to remember is if the government finds that there is a lack of compliance, there will certainly be follow up with respect to the employee that they're investigating, usually in the form of a revocation. In other words, the government will then send a letter that says, we're planning to revoke the visa, and then the employer has 30 days in which to rebut the findings of the officer. But it also can extend to a more serious investigation by either the USCIS fraud unit or another entity, for example, the U.S. Department of Labor. So it could be the case, if it were egregious, could be referred to another agency or another department within the USCIS. Did you want
Correct.
to say something
Yeah.
about? Yeah. So,
Right. So one thing just to remember with regard to the site visits is sometimes you want to make sure the credentials of the person is verified. I think David may go into more detail about that later. But sometimes with site visits, you may have I had a client that actually did not have a receptionist. They just had a key
hmm,
card entry to that particular facility, and it was very difficult for anyone to access their office to verify or even to meet anyone. It was just not the right location. So if there is a centralized location, maybe make sure there's signs in your facility to show that, if you need help, please contact, this number or something, so that the officer can actually, or the site inspector can actually get to some place where they can speak with someone. Because sometimes what we see is compliance issues can come up with regard to access. Like if they can't get into the building, they can't verify anything, and it could become an issue later.
yes, and we'll talk about this later. But if the company changes their location, then obviously that can be a problem because if the government goes to the location that's on the form and the government hasn't been informed about a move, then even though the company may be in full compliance, there could be issues. And that's why it's important to notify the government when there is a move, and we'll talk about that in a bit. Now, first of all, with respect to the site visits, there are religious worker petitions that are site visits. We're not going to get into that today. There are L1, uh, L1B, I'm sorry, L1 petitions and H1B petitions. They're saying that they conduct about 15,000 site visits per year. Now, that's quite a lot when you think about it, because there are 65, maybe 80,000 H1Bs. I don't know. Obviously, all of these are not H1B site visits, but you can imagine that it'd be about maybe 20% or so of maybe 1 out of 5, 1 out of 6 H1Bs that could be subject to a site visit. So it's important to realize that it's a definite possibility, especially if the company has more than 10 H1B workers. You can pretty much be sure that one of them is going to be targeted for a site visit. And again, we spoke about this slide, but basically the site visits are random and are generally unannounced. So that's an important thing to know, because you're not going to know when they show up. They're just going to show up at the door at the reception and show you ID and say that they're starting a site visit. So it's kind of a surprise thing. So you need to be
So
well prepared
David,
for that. Yes,
what do you think? What do you think about actual being prepared in terms of the site visits? Is there something that, aside from just having your paperwork in order, is there anything that a company should do in advance to prepare themselves for the site visit, or is there
absolutely,
anything that you suggest?
absolutely. So preparation again is going to turn on. And obviously being aware of what's in the petition and being able to explain what the beneficiary's work is, how that beneficiary fits within the organization, and being having available public access files and payroll records. That's in the H-1B context. The most important thing is to be aware whoever's going to be in charge of handling the officer. And I think that brings up another point. Every company should delegate someone within the company that has knowledge of the H-1B or L1, the L1 manager or a specialized knowledge person knows the position, knows how he or she fits in the position, and has readily available information about the organization and specifically payroll records and the public access file, which is something that is required for H-1Bs, available for the investigator to peruse.
Okay.
Okay.
Um, David, do you think it's a good idea to have the H-1B beneficiary involved in knowing about this possibility as well, given that
Well,
they may be?
yes, I do because as part of the investigation, the usually the investigator will speak with the H-1B or the L-1 visa holder to confirm what the duties are of this beneficiary. So it's very important, I think, to have both parties be aware of the possibility that they will be questioned with respect to what they do.
Okay.
Okay, so going to the next slide. Basically, we have this the when the site inspector shows up, they're going to come in and say, you know, we're here to do an inspection. We'll talk about this in a bit, but they need to show you ID. Um, they're going to look maybe about the company. They may ask about, you know, specific information about how many people work there. They may take photographs. Um, they obviously will verify that the company exists, and then they're going to verify the information that was submitted with the petition and review other documents. The most important document I think that they're reviewing is the salary, especially in the H-1B context, because it's that's a basically that's an area where there have been a lot of issues in the past. So the officers are focusing on whether the beneficiary is being paid what the company says it's paying that beneficiary in the labor condition application for the H-1B. And the other thing that I think is very important is again what we said before. The officer will confirm the beneficiary's work location, the physical workspace, the hours, the salaries and duties, and finally they will speak with the beneficiary to determine that all of the information that is on the form and submitted to this USCIS is correct.
Yeah.
Yep. Okay. Um, Now, the right now there's no legal obligation to go through the site visit. It's voluntary. There's the officer, the inspector can't force the company to do a site inspection. Certainly, if timing is bad, you can always try to request that the site inspection be changed to a different date, or maybe have the officer come back. But generally, because the information is supposed to be readily available, um, it looks usually looks bad if you try to reschedule things. It's better to cooperate. The only reason is if you have nothing to hide and everything is in line, it should be a fairly easy process, and it will go smoothly. So my feeling is that if at all possible, if the officer comes, try to accommodate the officer. How do you feel about that, Barbara? Do you think that's do you?
Yeah, that's a very good point because I think what happens in my experience in the past is if the officer was unable to, or the company was unable to provide specific information, but they do finish and go through with the site inspection, the officer may contact the company representative by email at a later date just to confirm some details. So that's happened before as well.
Yes, that is
So
good.
it's not like David said, it's definitely good to be honest and upfront and provide the information asked for. However, be aware that if you don't know something, you can refrain from providing that information until a later time. Just say, "I'm not sure. I need to check on that." But unwillingness to participate can raise the question about whether or not the documentation, like David said, should normally be available and normally be something that they can easily be able to verify because it's company information, basically.
Yes, that's right. Sometimes, Barbara put up a good point. Sometimes the company may not have, for example, the payroll records available, and at that time, the officer may give the company opportunity to submit those, usually by email, and that's okay. But again, if you're hearing this lecture and you know that you're going to get a site visit, it's certainly to your advantage to have that information available for uh, the inspector because you know in advance. Now, the next question is, uh, can an attorney be present? Again, I have not. I don't know. I mean, I guess we've had calls from managers who have a site visitor on site to confirm what they should say. So I've received that in the past. I haven't been asked to be present at a site visit. Um, Again, this is something that certainly you could request if you need to request it. But again, because the inspector is really just verifying very basic information, the position, the duties, the payroll about the company, very basic information, it usually isn't necessary. That being said, if you feel that this inspector is going beyond their scope of authority, if they're asking inappropriate questions or they're doing something inappropriate, you can always stop the site visit and ask for an attorney to be present. But you want to be careful about that. What do you think? What's your take on that, Barbara?
Yeah, I agree. And what do you think, David, if do you think it's a little bit too defensive to say I want to have an attorney present? Because I have the same experience as you, because sometimes they call and either I'm on the phone with or I'm on the phone with the company representative,
Yeah,
or it was right after the inspector had left. So there was no need for an attorney to be present. And I mean, my thought is the same as yours in that you usually should have that information available. If it's inconvenient, for example, if your company's having a specific event and the site inspection will interrupt that, you can certainly postpone it and then you can contact the attorney and schedule a time where the attorney can be present. But one of the basis for the random site visit is to make sure that the company is operating in the context of whatever representation was made on the H-1B petition, that there's no need to, redo anything or to present the beneficiary and the employment situation in reference to the H-1B because it's a spontaneous thing when they show up. So I think
right.
David, you agree that it's probably best that they may not need to have an attorney present for this type of
Correct.
circumstance.
I mean, unless there's really some sort of perceived abuse, certainly you can call your attorney during the site visit if there's any questions, or after the site visit, just to tell them. We generally get like an email or a call from HR after there is a site visit, just to sort of tell us that there is one, give us the heads up, and maybe ask us information to make sure that they've answered correctly. But that's about it. I really think that it's not something where you generally need to be represented. It's something that you need to be prepared for. That's just my personal opinion. Um,
Yeah.
Now, the next one is kind of an important one. When uh, s- the site when the inspector um, comes comes to the office, um, they need to have proper identification in USCIS credentials. They need to show the employer a business card. They may have a badge. The employer should always require that identification. The reason for this is because there are instances, we've actually had companies call us with sort of unscrupulous individuals that pose as officers. Even that's actually a crime, but we have had that done for various reasons by individuals who say that they're from CIS and here to investigate. And uh, it's important that the employer make sure that the site inspector is actually from USCS. One of the things you could do if the USCS gives you a card, you could actually call the number on the card and confirm with the USCIS office that that person is in fact an employee of that office. Barbara?
Exactly.
Okay,
I mean, that's exactly right because you never know. I mean, it sounds kind of strange that someone would be posing, but you never know whether or not the site inspector is bona fide, and you want to make sure that that's accurate, information they're providing to you. And they should do that because they're trained to do that when they actually appear for the site visit.
that's correct. So it's important. Again, the inspector will look at the premises. They want to make sure, number one, that the address on the petition is that of the petitioning organization. They're going to look for the sign, and they may ask neighboring businesses to verify the location and existence of the business. Now, this may be the time we need to talk about the Simeo case. Um, and there was a case, I think about 6 months ago, that basically, maybe it was a bit longer ago, that basically determined that if the employer changes its location outside of the metropolitan statistical area, which is basically an area that's defined by the Department of Labor as an area that sort of subsumes a specific metropolitan area. Usually it's about 25 mile radius. Sometimes it could be more. This is something that you could find out from your attorney as to if there's a move, whether it's within the same MSA, the Metropolitan Statistical Area, or not. But if it is outside of it, the government requires now in the H-1B context that this is only for H-1Bs right now, that the petitioner file an amended petition, a new petition for the beneficiary, informing USCIS of the change. In addition, the employer needs to file a new labor condition application with the Department of Labor indicating that change. Even if it's within the same uh, metropolitan statistical area, companies may want to consider even doing an amended petition only because, remember, if they do get a site visit and the officer goes to the location that's on the form and there's no one there and there's no one to say, hey, this company moved, a couple blocks away, um, then what happens is that the government will then initiate revocation proceedings. And that's really a pain to try to rebut. It takes a lot of time, and it can be a huge stress on the individual because their H-1B may be revoked, and it also causes a hassle for the company to respond to the revocation. So I, I legally, um, if the company is moving outside of the metropolitan statistical area, according to the Simeo memo, which is this case that came out about 8 months ago, the company needs to file an amended petition. Even within the same MSA, it may be a good consideration. With respect to L1s, the Simeo memo did not cover L1s. However, the same logic applies. Again, if a company has moved, it's probably not a bad idea to file. Barbara?
So, yeah, so David, what do you suggest for a company that moved within the same metropolitan statistical area if, say, they moved in a New York company, for example, to Brooklyn, and there was no amendment filed with USCIS. However, now all this information shows, and the company was in compliance. They reposted at
Right.
the new location. They
Yeah.
don't need to amend the petition. What would you suggest as a good way to ensure that the government knows where to find them?
I think it's more of a procedural thing that I would do with respect to the building. Maybe to certainly if it's in New York, there's usually a guard or someone in the building that could be notified to give people information as to where that company is. Maybe neighboring businesses, some just so that people know if it's they moved to Brooklyn, this is their address. I mean, the company could distribute a memo around just so that just so that someone knows if an officer shows up that they can be notified. What do you think about that?
Yeah,
It's an idea.
I agree. And I think nowadays the U.S. Site inspectors have as much access to technology as everyone, and I think it's good to make sure that the
Yes.
representation on your website and various media, outlets like, doing searches, you want to make sure that you update that information as well, so that if, for example, the building doesn't allow you to post a note saying you've moved or there's no one to ask, you can also have online information about your new address.
Oh, that's an excellent point, Barbara. Excellent point. I couldn't recommend that more. If you see even like Yelp or any social media, Facebook, anything that's public, obviously your website, putting in we've moved, this is our new address is a great way for the government to know. So I definitely would think that that's obligatory in this case. Um, so going back to what's going to happen if there is a site visit. We talked about this before, but basically they're going to look at the facilities. Now, if there's a part of the facility that's off limits to non-employees, would you want to give access to that facility to the site visitor, or I mean the site inspector, or would you say no? What do you think about
Yeah.
that, Barbara? If say there's like a laboratory or something that requires specific permission to enter.
Right. I think that's within the right of the employer to indicate that that's off limits. And also to say that, certain photography or certain taking photos of certain parts of the tour may or the facility may not be allowed. Remember, the goal is to prevent fraud. And there, when you demonstrate that the beneficiary for the H-1B is actually working at that location, the company is legitimately employing him or her, it should be satisfied. If the officer or the site inspector starts to ask questions that go beyond the scope of the H-1B or the L-1 petition, you can politely indicate that this is something that is company proprietary information. We don't share that with outside sources if it's okay, and then just politely indicate that. And I think that should be acceptable.
Yes, I agree, Barbara. I think that the idea here is really to show compliance, show good faith. If there's I would think that normally the inspector would want a picture of the building or the office, the entrance, showing the name of the company to show that it exists, because that's really what they're trying to do. And maybe they want to show, who's working there, how many people working there, or where the foreign national sits, maybe. But again, if that information is sensitive, I think that you can politely decline to give it, and that should be okay. Um, Now, what the most important things that the inspector will ask will cover about what happens, what the H-1B or the L-1 foreign national is actually doing. Um, So it's really important that the both the person that's delegated to be in charge of answering the questions. By the way, when the inspector comes, they will generally ask for the person who signed the petition first. And if that person is available, they can talk to them. If not, you can certainly delegate someone else to talk to the officer. But that's what generally they'll ask. It's really important for everyone to be on the same page with respect to the duties, the position, the work, the terms of employment, meaning the working hours, the location, all that stuff. Now, I recently had an inquiry from a company. It actually wasn't my client, but this company had. This is for an L1. Had a person in their office in California, um, and the L1 petition indicated, this is for a manager, an L1 petition indicated that they had three or four subordinates. The officer came to their office in California. The beneficiary was at the office. In other words, the L1 holder was at the office, but there was no one else there. So the officer proceeded to question the L1 beholder about his subordinates, and he said, "Well, I don't have any." And then the officer said, "Well, there are these people listed on your petition. Who are they?" And they say, "Oh, he's in. They're in another state. They're not in my state." And so basically, what happened here is whoever prepared the L1 petition didn't accurately uh, either the lawyer or the company didn't accurately describe who the subordinates are, and in addition, the L1B holder wasn't aware. So what happened in this case is the company received a notice of revocation. And then I don't know what happened after that because I wasn't involved directly with that. But basically, if they weren't able to respond, in this case, it sounds like they wouldn't be able to, given the fact that the subordinates don't exist. Well, they exist in another state, then that case would be revoked, and the person would have to leave the country and probably either obtain another visa if they could, or just forget about living in the United States. So it happens. It happens. We've had people in the H-1B context that weren't able to describe their duties. We've had salary issues. This happens actually more than you would believe, where the salary is supposed to be $5,000 a month, and they're really being paid $3,000. And they wake up and decide, oh, now we have to actually pay what's on the form. We've had that happen, and people sometimes just don't realize. So I can't stress enough the importance of being accurate on the petition, in terms of what the person is going to be doing, accurate in terms of the salary. In the L1 context, there's no minimum salary. You don't want to pay someone $10 an hour to be a manager, obviously, but you want to make sure that whatever you're putting down, you put down as the actual salary. Sometimes we have L1 holders that are being paid partially in a foreign country. We handle Japan a lot. So some people are being paid in Japan. You need to be able to explain that to the officer, show them proof, explain the issues, that there may be a follow up on that, because those get a bit more complicated and sometimes exceed the general knowledge of the officer. Um, I spoke a lot,
So,
Barbara. You want to
good
say anything?
question.
Yeah. Mm-hmm.
No, no, that's a good point. But let me ask you this, David. What have you had? How much minutia or how much detail do you think is acceptable for the officer to ask? For example, if the site inspector says, "Do you actually work 40 hours a week, or do you actually work 60?" Or have you had any situation where that level of detail was, raised
They
and
certainly ask how many hours per week you work. Um, I think my understanding is that the inspector is really looking is not looking at for example, are they paying overtime? Are they not paying overtime? They're just looking really at the wage, and is that wage being paid? So if the person is supposed to be making, $5,000 a month, are they being paid that amount? That's usually where it stops. I haven't heard about further detailed investigations, but it could be possible. I just haven't heard of that.
Yeah. Okay.
Mm.
I think moving on to the next slide, David, I
Yeah.
wanted to mention with regard to verification of employment,
Yes.
sometimes you have individuals that are, or possible questions, but just sometimes individuals may or may not be available. What if someone's on maternity leave, or what if someone is out on vacation? What has been your experience with the site visits when something like that happens? Has it been, have they scheduled anything? What is your experience so far?
I think generally, if it's a short-term absence, that the site visit can be rescheduled. Sometimes the officer will just speak the um, with the employer. Sometimes the officer could follow up directly by email with the employee or even by phone with the employee to verify the information. I think there's a genuine effort to try to get to the bottom of what's in the petition and to verify. Um, so going on to the next slide here, uh, again, they're looking at what's listed here. Um, these could be, these are kind of detailed, but it could go into detail with respect to, any repayment. What repayment agreement means is that generally the government looks at agree. For example, if the employer is sponsoring someone for permanent residence, and the employer makes the employee pay for all those costs, for example, that could be an issue. And they're sometimes looking at agreements to see if the employee is being charged back payment for legal fees or advertising fees, that kind of thing. Um, they may ask the employee about their background, their work experience, prior immigration petitioner history, how many H-1Bs, how many L-1s has the employer filed, even about the lawyer who's doing the petitions. I mean, there could be questions about all of these issues. Um, we generally, unless there's a more precise reason for an investigation, they're really looking at, I would say, three or four factors. Looking to does the company exist? Do I have proof that the company exists? Number one. Number two, um, what is this employee doing? Um, can you verify the position with the employer, with the employee, and finally, how much that person is being paid, and making sure that that person is being paid what they're supposed to being paid. Those are the main issues. But it sounds fairly simple, but believe it or not, there are a lot of companies that are not in compliance and they have problems. And we've seen over the years a number of revocations, because usually we see this after the fact, because we don't have the opportunity a lot of times to counsel people. And a lot of times they're not even clients that have used us, because we like to try to let people know about these things through the webinar, for example, today that we have attendees listening to. But in general, we're looking at people that didn't really know and weren't prepared, and then they're getting revocations. So this is something that we see a lot, not to some extent. Um, okay, so again, this is going to the next slide. Um, if the company is this is important. This is really really important actually. If the company terminates an employee, it is very important to notify the USCIS promptly, like the day or the day after they're terminated, and withdraw the labor condition application, which is something that you submit to the Department of Labor, because that at that point that's when the liability ceases. Once the USCIS is properly informed of a termination, once the Labor Department is properly informed of a termination, that is at that time that uh, liability ceases. Because if the company doesn't do that, then there have been cases where even a year or 2 years down the line, the company may be found liable to pay a salary to the person because CEIS wasn't properly informed of the termination. Right, Barbara?
Right. And absolutely. And I think that's one of the things where, about, I would say 15 years ago, this wasn't a big target issue for immigration. But nowadays, almost every employer is aware that there's liability, because there was the Department of Labor actually had found a company liable for back wages because they never notified immigration that they were no longer employing this H-1B worker. So I think it's definitely a big issue. And I just want to go back to a point where to mention that when you actually have an H-1B employee that's moved to a different work site, I've seen issues where the site visit was for the prior work site.
Yes.
The H-1B worker was not at that work site. The employer failed to notify counsel and failed to actually file anything. And then that H-1B was revoked. It was sent to the old work site. The only time this came up was when the employee actually went to apply for their visa with the approval notice and then discovered that their H-1B was revoked because they didn't realize that. No one knew. So it's
I
really
see.
important that whoever's responsible for keeping records or notifying counsel of changes in address be able to do so promptly so that there's no issues such as that, such as someone's status being revoked because they didn't realize that the case was already revoked. No one even knew about it.
Absolutely. That goes back to what we were saying before. It is really fundamentally important to notify USCIS of address changes. Again, the Simeo memo requires it in the case of a change of MSA, but even without that, it may be a good idea because these issues do come up on a regular basis. So it does happen, and it just creates a lot of problems. So really, it's very important to notify the government of any changes in the employer's location. And again, if the employee is changing, and we have this happen all the time, if you have a company, with offices in California and New York, and one guy is going from New York to California, you really have to amend the petition immediately. In fact, prior it should be done prior to the person moving. Under the portability rules in the H-1B, the person can start working as soon as that case is filed. So it's just it's really not it shouldn't disturb the workflow of the employee. Just it has to be done. Um,
Exactly.
Right. So basically, in terms of documents, and I said this before, but the kinds of documents that an inspector officer will request, the most recent pay stub, they're usually going to request maybe 1 month, 2 months, 3 months, a copy of the employee's W-2. Um, in the H-1B context, remember the H-1B has to be an employee of the company. We've had cases where H-1B, this hasn't happened in a long time, but we used to have people that were being paid on 1099s. You cannot do that. It has to be a W-2. Um, and uh, companies' tax returns, wage reports, things like that would evidence that the company is in fact a bona fide business. They may ask about the signature on the H-1B petition, H-1B or the L-1 petition, asking, um, uh, with respect to whether the signatory actually signed the document, that kind of thing. Um, Now, there's a little note here which I just want to mention. Um, the officers do not usually request to review the labor condition application of the public access file because that's something that the U.S. Department of Labor has jurisdiction. But they can request it only because the public access file is a document that should be available to the public. So anyone technically could walk into a company's office at any time and request to see the public access file. So that happened. Um, that happens, that's not a problem. That's something that they should have available. We do have a question, Barbara, from someone who said, I used the company's old address on a W-4 form. Would that be a problem? No, I don't think it's a problem because, again, that's something that's going to the IRS, the Internal Revenue Service. And in fact, on a W-4, I don't even think that's filed anywhere. It's a W-2 that's filed. I may be mistaken, but W-4 is the form that you give to your employer. So basically, this is a USCIS matter. Your company just needs to have updated their address with the USCIS, and the DOL maybe, but not the IRS. That's a different issue,
Right.
right?
I also, yeah, David, that's a good point in terms of the Department of Labor, because sometimes I think that the site inspectors, they have limited time. They're
Right,
not there to do full out review of compliance. So if they notice that there's issues with regard to the company's documentation, they may notify Immigration and Customs Enforcement if there's fraud issues, or
exactly.
like David mentioned, Department of Labor if there's issues about PAF files. They may want to see it, but they may not spend too much time on it. But they may take notes. So it's definitely good to have everything in place. Yeah.
Yes, absolutely. This is kind of a bit of a redundant slide, but just moving along here. They're going to ask for identification of the employer, of the employee, and they'll ask about payments made by the employee with the H-1B or the L-1 petition. Note here that DOL, and remember, DOL is not coming, but USCIS is coming. Their view is that all fees relating to the H-1B, L-1B petition paid by the employer, the USCIS will be concerned about the training fee, and this is with respect to H-1Bs because there is no training fee for L-1s, be paid by the employer, so they may ask about that. That being said, and this is a question we get a lot, does the employer have to pay for the legal fees and all of the fees associated with obtaining an H-1B or an L-1B? And what I've traditionally said is, if you ask DOL, they will say yes, and if you ask USAS, they will say kind of be like gray area and not answer directly because that's what our memos have said. Um, and certainly with respect to the training fee, clearly on both sides is required. The better practice, because you can certainly get an investigation, an H-1B audit, and this is in the H-1B context. They don't have them. The DOL is not involved with L-1s, but it's certainly in the H-1B context. You could get an audit, and that audit from the DOL would look to see if the employee is paying for the wage, and that could be assessed against the employer. So I think that it's just something to keep in mind when the company is considering how they're going to deal with the payment of legal fees, et cetera. The better practice is to pay for them. Okay. So the next slide is about what the employee is going to be asked. This is kind of, obvious job duties, responsibilities, when they're employed, where they're working, what they needed to requirement for the position, their address, and if they have dependents. Again, all of this information should be readily available in the petition. So if the employee has a copy of the petition letter or a copy of the forms, that information, that person should be able to know, understand, and make sure that they're able to speak about it intelligibly, and obviously it should reflect what they're actually doing.
So one thing to add here is with regard to any changes during the H-1B approval period. So sometimes what happens is, the foreign national actually gets promoted. If it's generally a promotion that was within the scope of the responsibilities that he or she was holding previously, an amended H-1B may not be needed. However, if the company is a startup or a new company and someone actually changed their job or their role, they had an engineering degree and they also had an MBA. And now their role is going to be going out to get clients. When they originally started, they would have filed for the software engineer role. And later on, the site visit comes up, and then the foreign national says, I'm actually going out and I'm a marketing manager now. But the petition was filed for a software engineer role. That would be an issue. So
Yeah.
I would just be careful about things like that, because sometimes once you get the person on board, you think, hey, their H-1B is good for 3 years. We don't need to do anything until we need to file an extension. That may not be the case if the job actually changes radically. So you want to, just be aware of that and possibly contact counsel if you have questions.
Right. And I think that's a fine line. I mean, I think the example that you gave, Barbara, is kind of obvious, right? A marketing to software engineer. But if they're doing something that's kind of closely related, but not really, you may want to check, the employer may want to check with counsel just to get their opinion as to whether, and we've had this question from several employers, whether, the person's been promoted, and whether that promotion is different enough, changes the job duties substantially enough to warrant the filing of an amended petition. And we usually look to see, there's no hard fast rule, but I think 50% or more of the duties are different than what the person was doing before. You probably want to file an amended petition. That's my own rule, but I don't know, if that's an actual a legal concept. It's just something that I tend to look at, and that comes, I guess, from the case law in the immigrant visa realm. But it seems to be a good rule to look at these things. That's what I usually do. So that may be a good rule of thumb, just to look to see if the duties are 50% or more similar or not similar. Okay, so again, other employees could be questioned after the investigation. Basically, if you don't hear anything, then that means you're good to go, no issues. If you get a revocation letter, then obviously you know that there's a problem. That's generally how it works. They don't come back and say everything's good, don't worry. They don't usually. You may get an indication that at the inspection that everything is okay. You may not, but you don't get like a letter or any sort of notice from the government that says we concluded your site inspection and everything looks good. They don't tell you that. So it's just that if you don't have anything, any follow up, then it's okay. So this is just a slide. The next one just goes over what happens. The tour, the company representative is interviewed, the H-1B/L-1 beneficiary is interviewed, and maybe they may interview the supervisor or coworkers as well. So those are the four things that the site visits generally include. And then, again, the site visit officer makes his or her report. It's reviewed by the service center, and then again, if there contains indicators of fraud, then USCIS will then assess whether further investigation is warranted. Now, what that usually means in most cases, and there may be exceptions because there always are exceptions, most cases that means that if further investigation is warranted, the next step is that the USCIS will send out a letter indicating that it intends to revoke the petition. Okay. Anything you want to add here, Barbara? Okay.
Yeah, I think you got it. I mean, basically
Okay.
the issue, yeah, if I don't hear back, generally means not, it's a good result, and
Yeah,
that's basically it as well.
I understand. Absolutely. Now, in terms of the outcomes, obviously verified, everything's okay, green light. Not verified, you get that letter. You could get further information, like in the form of an email from the officer. And finally, if you suspect fraud, then it could go to the next step, which is the case could be referred to ICE, and then you get a full-blown investigation of the company, and that brings it to a much higher level. So these things start kind of low level, but they could quickly escalate into a more serious kind of investigation. So that's why it's very important to be prepared, basically. And again, how do you prepare? Have a policy, protocol in place, be able to speak about the petition, have someone in charge, um, be have employers to talk with HR, other people to discuss the possibility, make sure they're aware of the possibility. Um, the employees, the H-1B holders, the L-1B holders, they definitely need to be, maybe even the supervisors to some extent need to be aware of site visits. It's very important that everyone be aware. So that's why and again, having a government official walk into an office may cause some concern for employees. So that's why it's also a good idea to let them know that these things happen.
Yeah, one thing I want to add here is just sometimes employees can be very nervous when a government official singles them out and has questions for them only when, say, they just randomly show up for a site visit. Just make sure that maybe in the beginning of the process, give them some feedback to say that this does happen. If you have a protocol, like David said, in place, maybe there's a document, like a one-page document, you give all new hires who are in H-1B status that this can happen and do not be concerned if it happens. It may be worthwhile just to emphasize that, that it's nothing to be nervous about. Because sometimes I think the employees, when they get nervous about it, they tend to be more suspicious about the veracity of their statements and things like that. So there's no reason to be worried. I mean, this is a routine, site inspection. It isn't something that they're singling them out for something. So I think, like David said, if you make sure that that happens, then the whole process the site inspection can go a lot smoother.
Okay, absolutely. And I agree with that as well. Just be prepared. Again, this is just a recommendation on this slide. Designate a company rep. Train maybe people in the front, security guards, receptionists. Just let them know this can happen. Obviously, educate the H-1B and L-1B beneficiary and the immediate supervisor. And finally, conduct an internal review to make sure that everything on the forms and the terms of employment are in accordance with the what's on the petition. That's important. And again, during the site visit, get SI the site officer investigator contact info. If you need counsel, you can decide on that. Maybe have another person present. If you don't know something, obviously you can provide it later, but try to be honest. And then just don't leave the. It's kind of obvious, but probably you don't want to leave the officer alone during the interview. You want to accompany them to make sure that any questions are answered and that they can have a proper explanation of everything. So that's about it. We've done our hour right now. Certainly, if you have any questions, you can ask them now, right now, by typing them. And if not, please feel free to send Barbara or I or Heidi is one of our associates in New York, and she can also be send questions as well after the presentation. So, does anyone have any questions? I don't see that we have any further questions on the control panel. Barbara, anything that you want to add or?
I think, basically you've covered everything. We normally suggest having a protocol in place. So if you need assistance with that, or we can help you with that, or if you have questions with regard to the protocol you already have, it's just a good way to be well prepared, for these types of random site visits. And as we see the increase in government scrutiny for all cases filed, through immigration, in particular, ones that the U.S. government may think is taking away jobs from U.S. workers. So we want to make sure that you're well prepared, that there's no possibility of the government misunderstanding whether or not the company is properly in compliance with any of the regulations.
Right. We do have one question here. Do I need to apply or they automatically send an officer to the office? That's the question. I think what the person is saying, if you apply for an H-1B or an L-1 and it's approved, then your petition may be randomly selected for a site visit. There's no way of applying or knowing whether someone's coming or not. It's just like a lottery. They may select you. So that's the answer. And the person now has said thank you. So I think we've answered that.
Oh,
Okay.
great.
Okay. So okay, I think we're done. Thank you so much for attending. We've recorded this lecture. We're going to eventually put it on our website and for people to listen to, for those who missed it. We hope you've all had uh, a copy of the PowerPoint, and we are doing these lectures on a regular basis. So please look at our website, or you will be receiving, of course, our e-blast with new webinars coming up very soon. So thank you very much. We look forward to hearing from all of you if you have any questions. Barbara?
Thank you for
Okay.
attending. Hmm.
Thank you so much.
Bye-bye.
Okay, bye-bye. Thank you.